Good afternoon, everyone. It is my pleasure to welcome you. I'm Robert George, Director of the James Madison Program in American Ideals and Institutions and McCormick Professor of Jurisprudence here at Princeton. I also want to assure you that we did not gin up what's going on in other parts of our campus in order to stimulate interest in the lecture topic for today with a distinguished personage and academic such as Professor Volokh. You don't need to do that. People will come anyway. It is a pleasure to welcome you to this 2024 Walter F. Murphy Lecture on American Constitutionalism. This is the lecture that we have every year to honor the memory of my great predecessor as McCormick Professor of Jurisprudence. Walter Murphy held that position for nearly 30 years. He established himself as a towering figure in two academic fields, first in the field of judicial behavior and then in the field of constitutional studies. It was under Professor Murphy that I was hired. My first teaching assignments at Princeton were to be his teaching assistant, what we call here at Princeton a preceptor, in his course in constitutional interpretation. So I feel that I was able to learn at the feet of a true master. I've since taken over that course myself, and it's a real honor to be following in his footsteps. For those of you who are not familiar with our program, the Madison program is dedicated to exploring enduring questions of American constitutional law and political thought. If you'd like to learn more about us, and I hope you would, please visit our website at JMP, James Madison Program, jmp.princeton.edu. You can also follow us on X at the handle @Madison Program. If you go to our website at jmp.princeton.edu, you can also sign up for our newsletter, subscribe to our wonderful podcast, Madison's Notes, and learn more about events like this one, upcoming events, some of which are still virtual, but many of which are in person. Well, I know how delighted Walter would be that this year's Walter F. Murphy Lecturer is Professor Eugene Volokh. Professor Volokh will be the Thomas M. Siebel Senior Fellow at the Hoover Institution at Stanford University starting just next month. He is currently the Gary T. Schwartz Distinguished Professor of Law at the University of California, Los Angeles, and will become emeritus in that capacity in July of this year. He has taught and written about First Amendment law for 30 years, and he's also focused on law and technology. He's written and studied Second Amendment law, tort law, and criminal law. He's the author of a First Amendment textbook, a book on academic legal writing, and over 100 law review articles. Before he went into law teaching, he clerked on the U.S. Court of Appeals for the Ninth Circuit for Judge Alex Kozinski and for Supreme Court Justice Sandra Day O'Connor. And before that, he spent 12 years as a computer programmer. This afternoon's lecture is co-sponsored by our Initiative on Freedom of Thought, Inquiry, and Expression. And Professor Volokh's lecture is entitled Speech That May Cause Illegal Conduct. Please join me in welcoming Professor Eugene Volokh.
Thank you very much. Great pleasure to be here. I don't believe I've ever been at Princeton, which is a shocking thing. I'm glad to have a chance to remedy this, especially on a lovely day like today. I also thought that because this is a talk, it's about illegal conduct generally, but a lot of that ends up being about violence. I thought it was exciting that I would be giving it in Aaron Burr Hall. And then I was gently informed that it was actually named after the father, who was apparently an unexceptionable fellow. So it's kind of a disappointment, really. But what I want to talk about is speech that may cause illegal conduct, including free speech that may cause illegal conduct. It is a property of American free speech law that there are certain kinds of speech that is protected despite its potential for causing illegal conduct. During this talk, I want to talk about various ways in which speech can cause illegal conduct and how modern First Amendment law treats it. In the process, I think we'll get to see a little bit about why it treats it this way. generally quite a speech protective way. What I'm not going to offer is sort of my view of the way the law should be changed. I'm open certainly to the idea of law changing, usually being a lawyer first and foremost. I try to figure out how to work within the existing system. But in any case, I think it's an interesting system to look at and to think about and to consider why the court has reached the results it did and why in some areas the results may seem a little bit different. And we can talk. There ought to be time. The event runs until 6 o'clock. Am I right about that? So I hope. Pardon?
We will have Q&A.
Right. So I'm hoping I'll talk maybe for about 45 minutes, and then we'll have time. We'll have time for a conversation where we can deal with some of these issues. All right. So let's begin with what may be to many the most familiar example of this question: when can speech be restricted because it causes illegal conduct, which is often loosely referred or kind of labeled the incitement test. As we will see, the incitement test is just a small part of the big picture. And there are other related things which actually people need to keep in mind that many people do not, and that are actually, some of them are largely unknown. But let's begin with incitement, in part because that is what the court first started to confront in the late teens and early 20s of the last century. And some of the cases ought to be quite familiar to many of you, but I'll walk through them and walk through some of the details. So let's start with abstractly urging illegal conduct, which is really what the incitement exception applies to. You might ask, why abstractly? It's often not what we talk about. Why illegal conduct and not violence? Well, it turns out it's more than just violence. It's also illegal conduct, and the abstractly point is important, but we'll get to that soon. So the rule is this: speech is constitutionally protected unless it is intended to and likely to cause imminent illegal conduct. And imminent conduct essentially means conduct in the coming minutes, maybe hours, probably not even days. There's a case called Hess v. Indiana from 1973, which basically characterized what might be seen as a call to take over a street the next day as not sufficiently imminent. So that's why one can confidently say there's a pretty tight time frame for this imminence requirement. So that's the legal rule. It's important to know the legal rule. But one question is why? Why is there such broad protection? After all, speech could lead to illegal conduct, even if it's not imminent, even if the consequence is not likely to, even if it's not intended to. And when speech does lead to illegal conduct, that's potentially quite harmful. One thing, of course, is the illegal conduct may also be very indubitably harmful conduct, various kinds of violence and the like. But even if it is dubitably harmful conduct, we'll get to, for example, advocacy and draft evasion and such, it seems contrary to democratic principles. If the democratic processes have yielded a particular result, it could be that there should be a draft, it could be a wide variety of other things. Doesn't speech that advocates violation of that law or leads to violation of that law, doesn't it do more to undermine democracy than to promote democratic self-government? That's the question. And there are a couple of helpful quotes. So here's a line from actually Justice Holmes from Frowork, one of the lesser known of the three 1919 cases where the court unanimously, in opinions by Justice Holmes, generally rejected constitutional protection for people on the grounds that the speech urged illegal conduct. Therefore, in those cases, draft evasion. So the First Amendment, while prohibiting legislation against free speech as such, cannot have been and obviously was not intended to give immunity for every possible use of language. We venture to believe that neither Hamilton nor Madison nor any other competent person then or later ever supposed to make criminal the counseling of a murder within the jurisdiction of Congress would be an unconstitutional interference with free speech. So one thing, of course, is this is a little bit of a stretch, right? In this case, it wasn't advocacy of murder, but advocacy of draft evasion that the prosecution was for. At the same time, generally speaking, the laws of complicity was what criminal lawyers call it, laws of aiding and abetting, of solicitation and the like, apply equally across crimes. Of course, soliciting murder is a more serious crime than soliciting lesser crimes, generally speaking. But soliciting all sorts of crimes is treated as structurally analogous. And, surely that illustration has got to be correct. It certainly remains so today. We're going to talk a little bit more about counseling or solicitation. But yeah, counseling of a murder in the sense of, I think you should kill this person, and let me tell you how, or let me urge you to do this, or whatever else, pretty clearly constitutionally unprotected. One thing is this kind of analogy. Here's another quote, and this is from Justice Brandeis in Whitney v. California. We'll see that actually Justice Brandeis ultimately concluded that speech ought to be protected, despite this tendency. But he didn't deny the possibility that speech can cause harm. He acknowledged it. I think he acknowledged it because he had to, because it's true. Every denunciation of existing law tends in some measure to increase the probability that there will be violation of it. Condemnation of a breach, so when somebody breaches it and one endorses that, enhances the probability. Expressions of approval add to the probability. Advocacy of law-breaking heightens it still further. So as a purely causal matter, one can cause a crime by urging someone to commit the crime, either concretely, as with counseling of murder might be, or more abstractly, just as much as one can by paying someone to do this, or by giving someone the gun necessary to commit a shooting, to perform a shooting or some such. Now, one might say that there are different levels of culpability, and in fact the law does conclude that, but from a purely causal perspective, all those are ways in which one can bring about criminal conduct that is often harmful conduct, and that by hypothesis is criminal because the majority views it as harmful. So we ask again, why such broad protection? Why has the court actually reached this broadly protective result? And there are many, many reasons for it. But let me start with one of the cases where, in fact, Holmes held in favor of restriction, and I think it's not clear, but it may be he continued to endorse that, even as he charted a more speech protective view in other cases. But at the very least, this today, most First Amendment scholars see that as the kind of case that has been repudiated by later cases, including that three-part test, which comes from the Brandenburg v. Ohio 1969 decision. So these are the candidates of the Socialist Party for president. This is in 1904, so Eugene V. Debs would have been some 14 years older then. So Eugene V. Debs was the perennial presidential candidate of the Socialist Party. At one point, I looked up in the Social Security files the frequency of the name Eugene, my very own, and it peaked in America in 1920s, and then every decade since it's become less and less popular. I was born in Kiev. I'm a Russian speaker by birth in Russia. Yevgeny is a perfectly normal name. In America, after I married my wife, she confessed that when she was a teenager, she and her girlfriends would tease each other. And one of the ways that they would do that is by saying that one of them will be married to a man named Eugene. So in any case, it used to be a big name, usually for the red diaper babies, is my inference from those particular statistics, probably because of Eugene V. Debs. So he was the candidate for president in 1920, and he actually ran for president from the prison, because he had been convicted in the Debs case, and the conviction was affirmed, for basically speaking out against the draft. And here is the characterization of the speech. And it's already small enough font, and there's going to be lots and lots on the screen, so I oversimplified, but I think for noble reasons. So Debs began by saying that he had been visiting three comrades who were paying penalty for their devotion to the working class, who had been convicted of aiding and abetting someone and failing to register for the draft. So he was praising, he was condoning the breach, he was praising the criminals. He said the master class has always declared war, the subject class has always fought the battles. There followed the interjection, you need to know that you're fit for something better than slavery and cannon fodder. And a final exhortation, don't worry about the charge of treason to your masters, but be concerned about the treason that involves yourselves. Then he told the jury, I've been accused of obstructing the war. I admitted, gentlemen, I abhor war. I would oppose the war if I stood alone. And from that, the jury could infer that one purpose of the speech, whether incidental or not, does not matter, was to oppose not only war in general, but this war, and that the natural and intended effect would be to obstruct recruiting. Because if you condemn war, it makes people wonder, whether they should go out there and fight and kill and die in the war. If that was intended, and if that would be its probable effect, it wouldn't be protected, even though it was part of the expression of conscientious belief. So one thing that I think we see here is that this could very well have been intended to bring about disobedience to the draft. Among other things, if you oppose the war, maybe making it less or essentially by reducing the manpower stock, that may lead your side to decide to settle the war. On the other hand, it also seems like a pretty powerful condemnation of the draft, which in a democracy has to be something that's on the table, right? One thing that we've had in all of our wars is elections, right? We had election in 1864 in the middle of the Civil War, where one of the candidates, McClellan, I think he was described as a pro-war candidate, but of a pro-peace party. And how much pro-war he was, pretty hard to know for sure, but probably not very. And could that have emboldened the enemy, led them to perhaps hold out longer, hoping that if they fight hard enough, then maybe the North will elect someone who will bring them to the bargaining table? Quite possibly. Likewise, there was no during the American participation in World War I. There was, of course, World War I ended shortly after the November election, 1918. But there was a midterm election campaign, while the war was still very much in progress. And one of the things we need to talk about as citizens of a democracy is: should there be a war? Should there be the draft? Is the draft just? Is the war just? So, in a sense, this case, Debs has become what some people call the anti-canon of First Amendment law. The canon is cases like Brandenburg v. Ohio, which I cited that three-part test from at the outset. Those are the cases that are kind of part of the standard foundation of modern First Amendment law. The anti-canon is the cases that this law is aimed at rejecting. So the plan of cases like Brandenburg is precisely so that people like Debs are not thrown into prison for expressing this view. Maybe because you say, well, this is a legitimate thing for him to say, but perhaps more importantly, it's a legitimate thing, it's an important thing for people to hear. So that was the general conclusion there. So that's a concrete illustration of that. So let me give you another quote, and this again may be familiar to many of you, but it's worth going over again. So this is from Justice Brandeis in Whitney v. California. Remember the same case where he started out by saying, yes, of course, criticism of the law undermines compliance with it or increases the likelihood of violation. So he sets forth what he thinks is kind of almost a catechism of free speech thinking. And it sounds, especially by today's standards, perhaps a bit goody-goody. It sounds a bit Yoda-like, as you will see in some parts of it. But there's, I think, a lot of sense to it, and certainly has become a foundational principle in the canon. So it says, look, liberty is... actually, it's interesting to know those who want our independence believe liberty to be the secret of happiness and courage to be the secret of liberty. That is almost certainly an allusion to Thucydides' funeral oration for Pericles. Interestingly, Thucydides is talking about that as a foundation for why it is important to gird yourself for war. Brandeis has a different he was certainly no pacifist, but he has different fish to fry with it. But it's a powerful figurative usage with a powerful connection. They believed that freedom to think were means indispensable to the discovery and spread of political truth. I won't touch too much on this, but many of you might know that there are different theories of free speech law. Some of them focused more on self-expression, some of them focused more on truth in general, some of them focused on democratic self-government. And here, Brandeis is talking very much about democratic self-government, about how in order to arrive at political conclusions, what we believe to be political truth, not abstract truth, but political truth as we, a democracy, announce it to be, we need to be able to think as we will and to speak as we think. And by the way, note the speak as you think is an important point here. One of the things that I suppose one could say is, look, if you are worried that you might go to prison like Debs did, under a legal test like the more relaxed, less protective one that was present there, is, well, why not just say, oh, I should just warn all of you, you should comply with the law. I'm only calling for a change in the law. Why not just throw in enough disclaimers so that people wouldn't think that one purpose of the test was to obstruct recruiting? Well, one possible reason is that may not be enough for you. Maybe the jury won't believe that you were sincere. Maybe the jury will say the real question is the effect more than the purpose. But part of it is also that we value the ability of people speaking as they think, not having to throw in insincere disclaimers, but be able to reflect what is genuinely in their minds. Discussion affords ordinarily adequate protection against the dissemination of noxious doctrine, and fitting remedy for evil counsels as good ones. So this is often discussed as the counter-speech principle, that it is better to rebut speech with speech than to suppress the bad speech. Note, he doesn't say that that's always, I mean, some people mock that by saying, well, look at all these bad ideas that have not been overcome by good ones. He doesn't claim that discussion always works. It just ordinarily affords adequate protection, not always. He doesn't claim that a perfect remedy for evil counsels is good ones. He just says it's the fitting one. It's the one that is most suitable to democracy, to a free people. That the greatest menace to freedom is an inert people, that order cannot be secured merely through fear of punishment, that it's hazardous to discourage thought, hope, and imagination. Fear breeds repression, repression breeds hate, and hate menaces stable government. Again, sounds goody-goody, but actually, if you look at the history of various kinds of governmental institutions, there's actually a lot of truth to it. That indeed, fear breeds repression, repression breeds hate, hate menaces stable government. That is how a lot of dictatorships have fallen. That in fact, the climate of fear and the repression that it brought, perhaps one might say repression breeds fear as well, bred essentially instability, bred people who were not connected to the government and not connected to the governing system, and that ultimately sometimes could not withstand military tribulations, and sometimes just the whole system imploded because it lacked the confidence of the public. So believing in the power of reason is applied through public discussion, they eschewed silence coerced by law, the argument of force in its worst form. So this is big rhetoric, but I think it helps explain a little bit why it is that we've reached what to some might be kind of an oddly overprotective rule. Why is it that speech intended to cause future misconduct is protected? Why is it speech that is not intended to cause future misconduct, that people know will cause future misconduct is protected? Well, because I think the court has, rightly or wrongly, probably rightly in my view, bought into Brandeis's principles, that on balance, that is the system that is most conducive to a stable democracy in which people can complain about the law and can debate the law and ultimately come to the conclusion sometimes that the law is unjust, it needs to be changed. And that if you're going to have people speak as they will, that kind of argument in favor of changing the law has to also include arguments that the law ought to be violated. Okay, so that's the big picture. And many of you may have already have seen this. I'm not sure I can completely promise to each of you, but I think most of you will find that from now on we're going to be getting to stuff that's actually a lot less talked about. So let's start with something that sounds very different, which is copycat crimes. So let's say there's a movie or a song or a news report that somebody sues, saying it negligently stimulates copycat crimes, suicide, and so on and so forth. There was a lawsuit against the company that released, I think, an Ozzy Osbourne song on the grounds that some teenager listened to it and committed suicide because the song glorified suicide. There is a lawsuit right now, there was, it's just been decided against it. It's still technically pending, but it's not going anywhere. The panel decision came out against the plaintiffs. But against Netflix, actually, I'm sorry, to be precise, the panel decision, Ninth Circuit panel decision came out on procedural grounds. But in any case, the lawsuit is lost. But it was with regard to the TV series 13 Reasons Why, which discussed suicide, and somebody allegedly watched it and supposedly as a result, hard to know for sure, the causation here, committed suicide, a teenager. Committed suicide. So they claimed, well, this negligently glamorized, this was negligently promoted to teens, and as a result led to suicide. There is a lawsuit against the makers of the film Natural Born Killers, on the grounds that somebody watched it and started killing people. So one question is, how do we deal with that? And the answer is, you go back to that test, right? That if there was evidence that some movie was intended to cause criminal conduct and was likely to cause imminent criminal conduct, almost impossible to show because it's very unlikely that any such misbehavior would be imminent, would be kind of right away in the immediate future. But if there was such evidence, maybe you could prevail against the film. But mere negligence is not enough. Mere tendency to cause bad conduct is not enough. So that's actually an important point. Again, one can debate whether that's right or wrong. I think it almost certainly has to be right, because otherwise it's hard to imagine how you could have a Romeo and Juliet, right? There are lots and lots of programs, lots and lots of entertainment and literature and plays and movies that glamorize suicide in some measure, or at least could be perceived as glamorizing suicide. There are many things that depict crime as glamorous, even if sometimes ultimately profitable, sometimes not, but in any case may lead some people to act. And part of the thing, and this, by the way, is also true with regard to even the advocacy of violence, you've got a situation where almost the entire audience will view the speech as entertainment, or in some situations as political advocacy or whatever else. Now, it's true that 0.01% who could act illegally could still be a lot of people, right? With these numbers, if it's 1 million people, then million audience, then 100 of them could commit crimes, and they could be very serious crimes. So maybe actually the numbers are even less than 0.01, but if it is 0.01, you can't restrict the speech that is available to the 99.99% in order to prevent the misconduct by 0.01%. In any event, so that's actually, there's no Supreme Court case on this point, but there's a pretty long and strong line of cases, long, broad, and strong, throughout the whole country, which basically reject liability, and that's a special case application of that three-pronged test that I mentioned before. Okay, now we're going to shift a little bit, and we're going to turn to this picture. So this is the late Cecil the Lion, and that's the dentist who shot him. And I believe that might be the guide. So Cecil the Lion. Why do I bring this up? So occasionally you may hear of this talk as the fashionable label these days is stochastic terrorism. So that is the claim that various people ought to be held liable, ought to be held responsible. I focus more on the legally, although there's a separate claim about morally responsible, for sharply condemning people in a way that foreseeably leads some portion of their audience to commit crimes against those people. Trump has been accused of that. Others have been accused of that too. So if you look back on this test at the beginning, you will see that these kinds of claims are highly unlikely to succeed. In fact, basically would not succeed under a properly applied test. Generally speaking, these claims, there's no evidence the person intended to promote illegal conduct against the person. Sometimes, there's often evidence they were reckless about it, in that they knew that this would happen, but continued despite that. This being some kind of illegal conduct, usually threats, because that's the cheapest form of illegal conduct for some of the audience to undertake. They may have known it was likely to, but almost invariably they're not. It's not likely to cause imminently illegal conduct. The worry isn't so much if Trump tweets something, then within the next hour somebody will commit a crime. It's just that over time, eventually, at some unspecified time in the future, someone might act on it. Well, so the reason I bring this up is, as you may recall from some 10 years ago, there was this outcry about the dentist killing the lion. This was in Zimbabwe, where lion hunting is legal, but the claim was that in fact actually the lion was illegally lured out of some preserve and such. But I think a lot of people didn't really care about the legality on the ground. They just love lions. Now I remember reading this op-ed in the Wall Street Journal by a American college student who was born in Zimbabwe on a village and said, "We do not love lions." Loving lions essentially is a luxury of those who get to live far away from lions. But in any event, lots of people love lions. My wife would have been very happy to, at the very least, punch the dentist. I hope no more. In any event, so unsurprisingly, when there were all of these tweets that went out, and of course news stories and other things. I shouldn't just say tweets. There was this vast 15-minute hate against the dentist. Unsurprisingly, he got death threats. He ended up leaving at least for a while to some undisclosed location. Again, when you've got 1 million people there's many more than 1 million. Some of them may just be outraged. Some may not care, but some will actually send threats or perhaps even physically attack him. Here's another example, and this is just a special case. I just found it from, it's not particularly famous, but it's a special case of this broad range of things where somebody was accused of some other misconduct, racism, for example, or it could be sexism or anti-Semitism or transphobia, whatever else. And then there's this viral condemnation of the person, and then at least there are claims that this leads to threats of violence. So this involved Eileen Cure, who was financial advisor, who was blasted on social media by allegations of racism after there was a video of her allegedly telling employees she won't interview black job applicants. Now, she denied this. She said it was false and defamatory. I don't know if it's true or not. But she also claimed that there were, as a result, threats of violence against her. Not implausible, right? Again, this fits this rubric of stochastic terrorism, because if one puts out even perfectly accurate, let's assume it wasn't defamatory, let's assume it was accurate, if one puts out perfectly accurate statements about someone mistreating others in a racist way, it's unsurprising that some fraction of people will be so incensed that they'll send threats. Again, it's important to keep in mind that threats of violence are a kind of crime which, while quite serious, they presumably the targets would take them very seriously indeed. Threats of violence are also the kind of crime that's relatively cheap for people to engage in, especially if they do it anonymously and don't have to worry too much about being prosecuted. So that's a very common kind of example. Here's another one which you may have heard of in the news. So there was a story about how officers and government officials in various jurisdictions claim that Chaya Raichik's Libs of TikTok account led to threats in their localities with posts that digitally heckle people such as drag performers teachers, members of sexual minorities, and doctors who treat transgender patients. Now, as I understand it, what Libs of TikTok basically does is it actually takes existing videos and broadcasts them. It doesn't make them up. It generally takes other people's videos, liberals' videos, hence the Libs, and broadcasts them to a wider audience. And unsurprisingly, the video may have originally been viewed mostly by people who are simpatico with it, and then ultimately it's seen by a broader audience, and some fraction of them again might react very badly to it. So why do I bring all of these up? Because this phenomenon is actually ubiquitous. You can come up with other examples from traditional media, although the internet does exacerbate it for various reasons. So, for example, if a newspaper publishes a story about someone who's accused of child molestation, or accused of defrauding the elderly, or something along those lines, it's unsurprising that there would be some number of people, probably a tiny fraction of the audience, who react to it by possibly threatening the person, or by going and throwing a brick through his window, or something along those lines. So, as a result, First Amendment law generally protects such speech because, among other things, if it tried to go after Hajrajcik, if the courts were allowed to go after Hajrajcik, they would go after everybody who condemned Cecil, not Cecil the Lion. Nobody condemned Cecil the Lion. Everybody condemned the dentist. And likewise, people who condemn alleged racists and so on and so forth. And there's actually a case on the subject, and I want to leave you with this because this is actually, I think, a very important case, and one that is not as well known as it should be, and one that is surprisingly relevant today, 40 years later. So the case is NAACP v. Claiborne Hardware, 1982. It also tells us a little bit about how slowly the legal system works. It dealt with the consequences of a civil rights boycott that basically ended in 1969. So NAACP organizes a black boycott of white-owned stores in, I want to say, Port Gibson, Mississippi, in Claiborne County. And some members of the NAACP act as store watchers, or black hats, because I guess there were black hats. They take down the names of people who aren't complying. Because, of course, if you're running a boycott, one of the things that might worry you is that some members of your community don't want to go along with it. They have their own preferences. But in order to coerce them, and let's be blunt about it, it was about coerce them, at least coerce them through the threat of social ostracism, their names were read at NAACP meetings and distributed on leaflets. And unsurprisingly, there were several incidents of violence against noncompliers. Thankfully, as best I can tell, nobody was killed, but there were shots fired through someone's window. There were a couple of physical attacks. So there's no doubt that this was speech that led to a crime. But the court nonetheless held that it's constitutionally protected. So if you want to have a stochastic terrorism example, that's the case. That's the one precedent, let's say. That's the one case that's on the subject. It's true the internet changes some things, but I don't think ultimately the internet changes that much. That speech is protected. So what is the speech? Publicizing the names of people you think are doing bad things, often as a means of publicly shaming them, in a situation where you're well aware that some fraction, a small fraction, but some number of people who are in your audience are going to act illegally or are likely to act illegally based on that, to attack them or threaten them or otherwise commit crimes against them. Nonetheless, that speech is protected. And that's true in as to Claiborne Hardware, as to the Claiborne Hardware case. It's true in the other examples that I gave. Okay, we're still in the context of speech that may encourage crime. We're going to get to a few other things shortly, but let me turn to one thing which I promised to talk about, which is soliciting specific illegal conduct. So if you're looking for news you can use, NAACP v. Claiborne Hardware, great case for cocktail parties. It's an indubitable, unanimous precedent. Nobody knows about it. You can shine. Solicitation is another example, because a lot of people talk about the incitement exception, that three-prong intent, imminence, likelihood test, as if that was the entire game, and it's not. So here's a particular fact. Speech intentionally urging crimes against the specific victim is constitutionally unprotected. And so there are a couple of cases on this, one called Williams, one called Hansen. I'm going to mush them together for practicality's sake, so it's an oversimplification, but I don't think by much. And they say, look, abstract advocacy of child pornography, that was the facts of Williams, or at least based on the facts of Williams, including the phrase, I encourage you to obtain child pornography, qualifies as protected speech. It's intended to promote illegal conduct, but not imminent illegal conduct. It's aimed at conduct at some unspecified time in the future. But the recommendation of a particular piece of purported child pornography with the intent of initiating a transfer is unprotected. So that's as to a particular piece of contraband. It seems pretty clear that it is also true with regard to a particular victim. So that ties into that quote I gave you from Holmes and Frowork. That it's true even today, counseling murder in the sense of soliciting the killing of a particular person or some other crime against that person is unprotected without this protection of the imminence test. So just an example, if somebody wants to put out a leaflet saying the police are oppressors and you should fight back against them even if it means violence, that's probably protected speech. Even if it's intended to promote illegal conduct, again, it's not imminent illegal conduct. But if you were to say, here's a list of the bad cops that I hope everybody punches in the face next time they see them, that is solicitation. And that is punishable without regard to the imminence requirement. I think also without regard to the likelihood requirement, probably. I do think that the purpose of soliciting is still required, and probably there has to be some explicitness. It's not enough just to say, well, we think the real reason you're condemning the dentist is because you really want people to attack him. And we are going to be prosecuted because of that, or sued because of that. The boundaries are not completely clear, I have to acknowledge. But what is clear is there is the separate solicitation exception, which has its own boundaries, its own rules, not coextensive with the incitement exception. Again, possibly broader in that it doesn't require imminence, but narrower that it requires specificity. Okay, now let me turn to another category of thing, which is you might think of speech that degrades moral restraints, and the classic example is obscenity. Now, obscenity is framed as speech that is patently offensive. So some people frame it as a restriction on offensive speech. But really, I think the rationale for obscenity all along was that this is speech that causes illegal conduct, or at least harmful conduct in the future. That conduct could be sex crimes. Some people certainly argue that certain kinds of pornography leads people to commit sex crimes. That conduct could be causing unwanted pregnancies, not itself a crime, at least today, but it may have been in the past the crime of fornication, of extramarital sex, but at least is seen as harmful behavior. Could involve the spreading of sexually transmitted diseases and various other things. Now, you can debate the degree to which it actually has that effect, but I do think that there is this notion behind obscenity law that the harm in large part is this harmful behavior in the future that comes about as restraints, important moral restraints on sexual activity are relaxed. So note, by the way, that this is a very different test from the incitement test, right? It isn't talking about immediate harm. It's not, well, or to give an example of something that has been defended more recently than obscenity has, restrictions on violent porn, on the theory that they cause sexual violence. Well, very few people will say what's going to happen is somebody watches violent porn and then 30 minutes later they're as a result of that going to go out there and commit a sexually violent act. Rather, the concern is over time their inhibitions will be degraded and their appetite will be whetted. That is very much not the talk of imminence, right? So the obscenity test does not, in fact, deliberately relaxes the imminence requirement. At the same time, the rationale of it is that supposedly obscenity lacks serious literary, artistic, political, or scientific value. So rightly or wrongly, the court accepted this because it said, look, we're talking about things that are outside of this political domain. When we're talking about political or moral advocacy or other such things, then in that case, we've got the Brandenburg incitement test. which is very speech protective. But when we're talking about things that lack any such value and instead are basically appeal to a prurient interest, defined as shameful or morbid interest in sex, we've got a different pathway to that. I'm not at all a fan of the obscenity test, and it turns out that the war on porn is over and porn has won. And so as a result, these laws are almost never enforced. But it's worth thinking about it as a way that the court had tried to deal with at least one supposed way of speech causing illegal conduct. Note, by the way, future or later attempts to try to apply this by analogy have been largely defeated. So the clearest example of that came in the violent video game case, just about 15 years ago? No, I think that's about right. And there, it was actually a very modest restriction of violent video games. It only prohibited the sale of violent video games to minors without the parents' permission. So if the parents wanted to, they could still buy the games for minors. They weren't even banned for minors. It's just that minors couldn't buy them on their own. And by the way, Justice Thomas would have upheld the law on the grounds that he said, look, these are children. And, you know, all sorts of things should be allowed to protect children, to prevent children from doing certain things that wouldn't be allowed for adults. But the majority, by the way, written by Justice Scalia, disagreed. Now, one rationale for this law was, look, it's just like obscenity, only for violence. In fact, it was written in terms of obscenity law, but as adapted to violence. Shameful or morbid interest in violence. And it's even narrower, because it doesn't interfere with what consenting adults can do. It only shields minors. And in fact, laws limiting distribution of obscenity to minors are still enforced. No, said the court. The rationale for the obscenity test was a historical one about special treatment. One can say rightly or wrongly, but there was in fact a historical such treatment of sexually themed material. We're not going to extend it beyond its historical rationale to violence. A later case said the same about animal cruelty. Okay, so we've talked about incitement, we've talked about stochastic terrorism, we've talked about solicitation, we've talked a bit about obscenity. Let's talk about a couple of other things. Oops. So one is, what about speech that facilitates crimes? This isn't speech that persuades someone to commit a crime. It's not speech that advocates a crime. It's that it gives them information that makes it easier for them to commit a crime. And I'll give you a list just to show just how many things implicate that. So one is warning that police are coming. Some of it is things that pretty clearly are not, nobody would view as First Amendment protected. Being a lookout. There's a gang that's robbing a house. You're there only as a lookout. You're not actually robbing anybody. But you are alerting people if someone's coming. That's clearly a crime, right? It could be conspiracy, it could be aiding and abetting. But there are other examples. What about you flashing your lights? How many people do that? You don't have to show your heads. Flashing your lights to warn people about a speed trap. That's kind of like you acting as an impromptu lookout for people so that they can get away with committing the crime of speeding. To be sure, you're encouraging them to stop speeding, but only very briefly. You're making it easier for them to get away with speeding. What about revealing a secret wiretap or subpoena? There are actually injunctions that often happen when a service provider gets a wiretap or subpoena. It's so-called gag orders that bar them from disclosing it. What about maintaining a site with copies of term papers? I realize this is just quaint now with ChatGPT, but these are old examples from an old article of mine. What about publishing the names or addresses or social security numbers of boycott non-compliers? Note that NAACP v. Claiborne hardware case may be seen as a crime facilitating speech case. Or police officers or informants or jurors. What about publicizing vulnerabilities in a computer system or a fingerprint lock system? And when I wrote an article on the subject about 20 years ago, one example that I gave is somebody who wrote this paper for a security conference, where he said, look, everybody's telling you to use these fingerprint lock systems. I can show you how you can defeat these in 20 minutes for $20. And I have to show it to you because otherwise you might not believe me. It's not enough for me to tell you you can do it. I have to show you, so I'm going to show you. And I think it wasn't actually intended to be posted on the internet. It was just at a conference. The proceedings were posted on the internet. And now everybody can can read that and figure out how to do that. Or how about explosive making manuals? They could be anarchist cookbook, or they could be road construction manuals or chemistry textbooks. In fact, if you look at what actual bomb makers, illegal bomb makers, actually have in their labs when they're raided, it's not the anarchist cookbook, right? Because they're not idiots. They're criminals, but they're not idiots. They have chemistry textbooks. They have other such things. Or there's a famous case involving Hitman, the contract murder manual, written by one Rex Ferrell, which is a pseudonym for this housewife with 3 children who, as best I can tell, not that she couldn't be a contract killer, but as best I can tell, was not actually a contract killer. But that actually led to at least the court saying that there could be liability for publishing that. So I want to flag this. I wrote a long article on the subject. I don't have the time, or you don't have the inclination to listen to all of it now. But let me just highlight that these are all important issues that the Supreme Court has actually never spoken to. Advocacy of crime it's spoken to. That's the Brandenburg case, which I started the talk with. The stochastic terrorism stuff it's spoken to, that's NAACP v. Claiborne Hardware. This it hasn't. Just a few things I should mention. It is pretty clear it's usually protected. There's enough case law that makes clear that just because speech informs someone to commit a crime, it's generally not unprotected. Maybe not if it lacks substantial non-criminal uses. So like, for example, what about passwords? What about social security numbers? Or I think that can help explain the lookout. Like if the lookout is just informing fellow gang members, oh, somebody's coming, that's something that is really used only for criminal purposes. A more controversial question is, what if the speaker has the purpose to facilitate crimes as opposed to just knowing that his speech will do so? The Justice Department has argued, and some courts have accepted this, that that is the proper line. So if you're publishing a book about explosives and your goal is to help people commit crimes, well, then in that case, that could be made a crime. But if you're just aware that it will help some readers to commit a crime, but that's not your goal, it's not. It's an interesting theory. I'm skeptical about it in part because purpose tests, pure purpose tests, without extra protection like the imminence requirement and the like, end up being too likely to over-deter speech, I think. But not everybody agrees with me. In fact, probably most people don't. By the way, there's an interesting question, the special case of home addresses. And I brought this up in part because I just wrote about this on my blog yesterday. It was from a court decision, I think from Thursday or Friday, from New Jersey. New Jersey has this law. Actually, I'm sorry, New Jersey, this very state of New Jersey. I should have thought of this. By sheer accident, I'm localizing this talk. So there has a law named Daniel's Law after, I think, the son of the judge after the son of the judge who was murdered by someone who came to her house. The son and the judge's husband were murdered when a disgruntled litigant came to the house in order to get revenge. So under this, various police officers and judges and some other government officials can demand that their addresses not be published. And this journalist, I want to say New Brunswick, went to court saying, I want a declaration that I'm entitled to publish the name and address of this police chief of this town. Because I think he lives 2 hours out of town, and I think I've got the goods on that, and that's why he's not showing up to various city meetings and such. And the court, the New Jersey Appellate Division, said, oh, that is not protected. Because even though criticism of the police chief is speech on a matter of public concern, the specific address is not a matter of public concern. Interestingly, at least 3 other cases, I'd say at least 3 other cases have held the opposite. So there's actually some disagreement. Maybe it's the sort of thing one day will come to the U.S. Supreme Court. Interestingly, actually, one of the things to keep in mind is home addresses are indubitably useful for criminal purposes, but also for non-criminal purposes. So, for example, in most of the country, it's lawful to picket outside of people's homes. The court said that a content-neutral ordinance banning such picketing is constitutional, but most places don't have such ordinances. So if you can picket outside a person's home, presumably you have to be able to inform people where to gather for that, right? And to get information about the person's home. Likewise, there could be discussions of whether government officials are living out of town, or discussions of disputes between neighbors. It could be, oh, there's this dispute between these people, and one of them happens to be a police officer or a judge or whatever else. I was actually involved in one such case, not as a neighbor, but as a lawyer. It's hard to write about that without saying something about where people live. And implicitly, you're publicizing the name of the neighbor might allow people to figure out where the neighboring police officer lives. So lower cases are mixed on this, an interesting and important question. So let me close substantively with the last thing, was what about speech that tends to cause illegal conduct by making people angry? So it's not that you're, making people angry at the speaker. A lot of the speech, Debs was trying to make people angry, right? A lot of the speech that advocates illegal conduct tries to persuade people to engage in illegal conduct. This is speech where the speaker doesn't want, presumably, to be attacked, but might nonetheless. So the general answer that the court has given is that there's no so-called heckler's veto. Participants in an orderly demonstration in a public place are not chargeable with a danger. That is to say, cannot be sued or prosecuted for what they say, with the danger that their critics might react with disorder or violence. That they can't be prosecuted on the grounds that, look, you knew you were making the crowd angry, they're about to start attacking you, we're going to arrest you because you refused to disperse at that point. So that typically what happens, the police officer sees the crowd, sees the guy, says, it's easier for me to arrest or to stop the guy from speaking. It says, I demand that you stop speaking. The guy says, no, I won't. And then the police officer arrests him. That's the classic heckler's veto, and the court generally rejected that. If you want an example, it's the leading recent case is a en banc case, that is to say, a case by a circuit court sitting in all the judges and not just three-judge panel from the Sixth Circuit. This was in Michigan, where a group of self-described Christian evangelists preaching hate and denigration to a crowd of Muslims, some of whom responded with threats of violence, led the local police officers in Michigan to remove the evangelists. The court nearly unanimously, there was one dissent, but I think maybe about a dozen judges in the majority said that's unconstitutional. That even when speech may lead to crime by the audience, you have to punish the audience and stop the audience, at least unless you're completely overwhelmed as the police, rather than restricting the speaker. There are various arguments for it, but I think the best rationale is the old familiar principle of applied psychologists, which is behavior that gets rewarded gets repeated. That if you allow a heckler's veto, you're going to have more hecklers. You're going to have more people that see, oh, if we just attack the person, or more likely threaten to attack the person, then the police will do our job. We'll do what we want. The police will block the person from speaking. But there's an interesting and important exception. And this is one you may have heard of before. So we started with a relatively familiar thing, incitement. We're closing in a relatively familiar thing here. And it's the fighting words exception. So there is an exception for basically personal insults, but it's important to realize how narrow it is. It deals with face-to-face, personally abusive epithets directed to the person of the hearer that are inherently likely to provoke a violent reaction. So in certain situations where basically it's not political advocacy to a large group, even a group that you know perfectly well are going to be mostly hostile to you, but when it's specific statement to a specific hearer that is basically a personally abusive epithet, not just something that you know they'll be offended by, but something that targets them as a person, that is something that remains punishable. Almost 100 years after the court case, let's say 80 years after the court case, Chaplinsky v. New Hampshire, that recognized this. But this has been made into a very limited exception by the court, and one that does little to undermine this general principle when it comes to advocacy more generally. So we've actually come to the 5:30 mark, and I thought I would just open things up for a conversation.
Good. Thank you, Professor Volokh. Okay, so we have members of the Madison program staff who have the microphones. If you have a question, raise your hand, I'll recognize you. A member of the staff will come over and will hold the microphone for you to speak into. Our custom in the Madison program is to reserve the first part of our Q&A for students. So if there are any students who would like to launch us, graduate students, high school students, undergraduates, you have the floor first. Well, right over here. Please, John.
Hi, Professor. Thanks for your time today. I'm wondering, with all the ongoing protests across
Yes.
the country, which category you would put them in. I'm not talking about people who are taking over buildings or
Right.
setting up tents, violating any
Right.
university policies, but purely saying things that are controversial, offensive,
Right.
and could definitely at least be construed to incite violence.
Right. Well, so the question is, what is it that is actually being said? So for the protests that we're seeing now, by and large, are basically protests about things that are going on overseas. So when people talk about advocacy of genocide, let's say, and it's an interesting question what exactly counts as genocide, it's pretty clear that nobody is saying, well, excuse me, I shouldn't say nobody, that when they're saying, oh, you know, let's assume they say, Hamas, we want more October 7th, as I'm told some people say, you know, that's advocacy of violence, but that is advocacy of violence by Hamas against Israel. One could morally condemn it, I certainly do, but that's not advocacy of illegal conduct by the audience, certainly within the US, but more broadly by the audience. So the rationale for the incitement exception, which is that, look, if you're intending to and likely to cause imminent misconduct by your audience, you're kind of causally producing this, then if all those elements are satisfied, you should be held responsible for it, just doesn't apply if what you're saying is, I wish these terrorists overseas, who I'm quite certain are not listening to me personally, actually commit those acts. So that may be highly offensive, but that is not at all incitement. Likewise, if somebody says, not that I've heard much of this, but you can certainly imagine someone saying it, and perhaps legitimately, oh, well, you know, I think Israel should hit even harder back, and it should kill more Gazans until Hamas gives up, that too is constitutionally protected speech. Now, of course, all depends on what is actually said. So if, for example, what is said is, and we should go and throw bricks through the Hillel building, that is, even if it's not imminent, that is solicitation. It's solicitation of a crime against a particular target, right? Likewise, if you're talking about causing violence because some people might react violently because they're so violently angered by this. I have heard little talk about this in these kinds of contexts, but you can imagine that. The answer is generally that is not adequate to justify the restriction. But if there is a personal insult to somebody, then in that case, that could be fighting words. So it all depends on the particular factual circumstances, but the big picture that I'm seeing, I think there are lots of perfectly sound objections to people breaking into buildings, as I'm told happened in Colombia, or taking over space that's supposed to be shared space, or at my own UCLA, I understand, I haven't been there physically in the last several days, but that some of them just sort of block off certain space so students aren't allowed to go. It's not just that it's physically there are tents there, but there are people who are blocking them from going. That's illegal, that's a crime. It's a violation of content-neutral time, place, and manner restrictions on speech. But it's not punishable as incitement or a solicitation or what have you.
Other student questions? I see some students from my civil liberties class. Do you want to ask a really impressive question to show how well educated you? Yeah, here we go. Right.
I'm curious about the historical precedent coming to obscenity law and that not extending to violence.
Yes.
I was under the impression that historical precedent is usually used to restrict how a judge could rule or how a jury can rule on a law, but it's typically not used to strike down what is passed by a legislative body. So how does that work in this situation?
So, generally speaking, when there are constitutional constraints, could be First Amendment, could be Fourth Amendment, could be whatever else, courts have long recognized history and tradition as one of the things that influences those constraints. So as a result, when those are constraints on the legislature, as many constitutional constraints are, indeed, history does limit that. If you want a classic example from perhaps to some unexpected source, let's look at Justice Brennan and his work on the Establishment Clause. Justice Brennan took a pretty broad view of the restraint that the Establishment Clause imposes on government action with regard to religion, including government funding that ends up going to religious schools and such. I think too broad, by the way. I don't agree with his position there, but he certainly did take this view. And he, at least the rationale that he often gave is, look, the Establishment Clause was understood as basically securing in the Constitution certain kinds of historically recognized restraints on the union of church and state. And that therefore a state statute that provides for funding for private schools, where much of the funding, or most of the funding, almost all of the one for private schools, and some portion of the total school funding goes to religious schools, is unconstitutional. Why? Because that's the history. That's the tradition. So it's quite familiar in that respect. Now, in recent years, the court has done the same with regard to other provisions. So I'll get to free speech in a moment, but just to show that it's not just a free speech thing, the Sixth Amendment secures a right to confront, of criminal defendants, to confront the witnesses against them. Starting about 20 years ago, the Supreme Court, in some opinions that were, I think, written by, certainly were enthusiastically backed by Justice Scalia, who was a big advocate of this, but also joined by the liberal Justices Stevens, Souter, and Ginsburg, and I think generally Justice Thomas as well, from the right, said, well, that the Confrontation Clause means that those procedures that were kind of understood at the time of the framing, that you can't, for example, introduce out-of-court depositions of witnesses if the witness isn't there to be cross-examined. Those are part of the constitutional requirement. And if a state legislature provides for evidence code, California, for example, has a statutory evidence code, if the state legislature provides for an evidence code that allows the admission of those things, that's unconstitutional. Likewise, starting in around 2008 or so, the court has more and more turned to history as a bound on these exceptions to First Amendment protections. So the court says essentially, yes, there's a libel exception because it had been historically recognized. That much is surely true. Libel law has long been understood as an exception from free speech protection. There is a obscenity exception because it's long been historically recognized. So if a legislature sticks with a historical tradition, then it may be able to get away with it subject to various limits we've placed on that as the Supreme Court, because there are some precedents that limit certainly obscenity law and libel law and such. But if the legislature tries to restrict speech that's outside of this historical exception, then in that case, that is presumptively unconstitutional. It's going to take a lot for us as the Supreme Court or for lower courts following our instructions to enforce that. And in fact, that's exactly how the violent video game case worked. That the court said, look, it's true this is modeled on the obscenity exception, but the obscenity exception is an exception for historical reasons. Historically, there has been a limitation on free speech as to certain kinds of highly sexually themed materials. That exception has never extended to violence. We're not going to do it here. So if you want to justify it, you have to pass the so-called strict scrutiny test, which is a very demanding test. So yes, when it comes to constitutional rights, history and tradition have been seen as constraints on legislative action as well as judicial and executive.
Floor is now generally open. Anybody can ask questions. Yes, Professor Kelly. Tom will just catch it on the video, on the audio.
Thanks, Eugene. I wanted to ask about the three-part test. And I take it that the imminence requirement is within the scope of the intention requirement. So
Imminence applies to both intention and likelihood.
Okay, so as long as my intention isn't that this thing happens imminently, I'm in the clear, if I could show that.
Yes, so long, even if it might happen imminently, if you're just talking about action at some abstract time in the future, unknown time in the future, you're in the clear. Yes?
Okay. So I wanted to ask if you could say a bit more about the rationale for that.
Right.
I mean, there could be, a relatively superficial thing would be just, well, if you didn't have that, we would end up with more speech being unprotected,
right.
Justices were comfortable. But you might think that doesn't really carve things at the joint in some deep philosophical way, right? I mean, if suppose I was indifferent, it was important to me that this terrible thing was done, but I was indifferent to whether it happened a week from now or within the next hour. Right. You might not think that's where the line, and I really did intend this fully. But I was indifferent with respect to that time issue. It's not obvious that would cut things at the joint in the right kind of way. So is there some deeper rationale for this?
Yeah. My general rule of thumb for law is people who expect deep philosophical satisfaction from law are in for heartbreak. In part because, so this is the famous line from Holmes, the life of the law has not been logic, it's been experience. So in part it's because they're just historical accidents. But in part also because, justices are not philosophers. They often resolve cases based on what seems like a plausible rule at the time, and often with an eye towards practicalities. So there are a couple of rationales that are given. One of them is the one that Brandeis gives in Whitney, which is that discussion affords ordinarily adequate protection against the dissemination of noxious doctrine. And the fitting remedy for evil counsels is good ones. And there's another part that I cut out just because there's already plenty here, where he talks about so long as there is time available for discussion. That is the remedy. So the theory is if you've got a mob in front of a building and there's being egged on to burn it down, now, maybe that's actually governed by solicitation exception, but let's say they're not being egged on to burn it down, but they're egged on to burn society down, and they're going to turn to this building. Then you might say, look, there's no time for counterspeech. You got to stop the person, stop the mob, and then we can talk. Whereas if it is about something sometime in the future, there is an opportunity for people to speak. It's a highly imperfect opportunity. Again, the remedy for evil counsels is not perfect. The good ones are not a perfect one, but it's the best one we've got under the circumstances. So that's one rationale. The other rationale may have something to do with the Debs case and with the limitations of a pure purpose and imminence test, and likelihood test. And that is that as a practical matter, our ability to determine a person's purpose, and in particular to distinguish what they intend to cause merely from what they know may very well be caused, is quite flawed. And it's flawed in part because of a feature of human nature, which is that we always assume the best motives of our friends and the worst of our enemies. That's normal human behavior. So the problem is, in the absence of an imminence test, it becomes very easy even for someone who is perfectly well-intentioned to have bad intentions imputed to him by a prosecutor, by a jury. In a civil case, you don't even need proof beyond a reasonable doubt or a unanimous jury, right? So if indeed, imagine that the test was not with imminence. Imagine the test was simply, you can be punished or you can be sued or you can be imprisoned whenever you intend to cause illegal conduct. And you're explaining what all is bad about the law. You're explaining what's bad about marijuana law, which is still illegal, of course, at the federal level. Or saying what's bad about the war on cocaine. And you talk about, lots of people really enjoy cocaine. Some people really suffer from it, but some people enjoy it, and isn't really something that everybody ought to be free to do. We can kind of come up with all these things, and somebody says, aha, deep down inside, I know you actually want people to go out there and take the drugs. Marijuana is actually an excellent example because marijuana has a lot of cheerleaders, right? A lot of people actually do think there would be a better world if people consume more marijuana. So then the consequence is, especially if you were like an activist before, you'd become a kind of a convenient, or not even convenient, that suggests disingenuousness. I'm talking about sincerely. Prosecutors may assume, of course, the things you are saying in praising marijuana, you claim is because you want to repeal the law repealed. What's really going on is you want to see the law violated. So I think as a practical matter, that kind of the imminence threshold has been seen as an important backstop, as an important way of making sure that people have some security in being able to speak without bad intentions being imputed to them.
Yes, up here.
This is just sort of a brief additional question to that, which is, has the court considered, a highly intentional speech inciting violence that has a definitive date that's far in the future? Let's say that I, publicly was attempting to incite some sort of violence on the election 6 months from now, and I was inciting it, and I was sort of causing a group of people to join me in that. But a week before the election day, I stopped posting anything online or saying anything.
So
even though it had a definitive date, and let's say the crime did occur. Has it considered that?
So let's take a concrete example. Imagine someone says, I think Trump is a menace to democracy. And if Trump is elected, we should all take to the streets. And if that means a revolution, that's what it takes. No, that is clearly constitutionally protected speech. Now, if you were to say, on election day, I want you to bomb the Capitol or whatever else, or something else pretty specific, or for that matter, on election day or before or after, anybody who wants to, who can get a shot at Trump should kill him, let's say. That would be solicitation. Solicitation does not have an imminence requirement. So indeed, if you are actually talking about a specific target, and especially if it were unconditional, although perhaps even if it's conditional, there's not a lot of case law on the subject, that probably would be punishable if it's specific enough. But if it's in general, again, if the following thing happens, then come election day, this is what we need to do to take back the country, whether it comes from the left or from the right or from anywhere else. That's quintessential example of what's protected by the incitement test.
Yes, down here, sir. And then we'll go up there.
Can I just speak, or should I wait for the...
No, the mic's right there.
It's right there.
Yeah, she'll hold it for you.
It's not far.
Yeah, as Trump's defense attorney, for the claim that he, on January 6th in the morning, made a speech that he was soliciting certain behaviors associated with incitement, how are you defending Trump's speech that morning?
I'm always hesitant to get into specific factual details because a lot turns on specific factual details. But my guess is that that the argument would be, and by the way, it isn't just incitement, right? He could be accused of soliciting a specific attack. He did not intend to do that. What he intended to do was to get people to go and sort of show that the Republicans, if you don't do things my way, you're going to be primaried. You're going to lose support. You're going to lose elections. And in fact, that would have been a much more practically useful thing for him. I think most American politicians are pretty brave when it comes to physical attack. They're not going to say, oh my God, they're about to charge into here. We're going to vote the way we want them to. They want us to vote. They would probably try to get away, as they should. But physical intimidation, I think, doesn't work very well against American politicians. Electoral intimidation works very well against American politicians because it's actually supposed to, right? That is sort of one feature of democracy, although it's a virtue that could be taken too far and become a vice. So I think the defense would be, if it were in a criminal case, the defense would be that he did not have the purpose to do this, among other things because it ended up being very bad for him. And it would have been foreseeably very bad for him. It's quite unlikely that that is what he actually wanted to see happen. That would probably be the strongest defense. And note, in a criminal case, all you need to do is establish reasonable doubt. Right now, a lot depends on the jury. In the D.C. is very much a one-party town. So if it were in D.C., then it may be that you might think the jury is either unfair or maybe unusually enlightened or whatever else, depending on your perspective. But you do have to prove beyond a reasonable doubt to a unanimous set of jurors. So that's probably what I would say.
If I could add to that, Eugene.
But nobody's hiring me as anybody's defense attorney.
If you haven't read the case of Brandenburg against Ohio, which is the prevailing law on the subject that Professor Volokh's referring us to here. I find that my own students are really astonished. My students can tell me if I'm wrong about this when they read the case at how difficult it is under the Brandenburg standard to prove imminence and intent. It's very, very difficult. And I think that would help to explain why there's not an actual prosecution. The prosecuting of everything else in the world.
Right.
Under Brandenburg, it would be very hard to make the sale in a way that would, even if you got a friendly jury, that would stand up on appeal.
Right, you know, in a criminal case, there's a lot of difference to juries in appeal.
Next question. You know, I said I'd recognize this fellow over here. Yeah, please.
Is there a situation in which the government might have an extremely compelling interest to prevent speech that is not intended to incite violence, but is likely to cause imminent or illegal conduct?
You know, it's very hard to talk in the abstract. So I'll give you an example of something that is often given, although that's probably on the crime facilitating speech side. That is publishing the sailing dates of troop ships. Again, a quaint example. We see it from Nearview, Minnesota, 1931. In an age of satellites, it's a different matter. But yeah, that's an example of something where, you know, if I publish the sailing date of troop ships, the attack on the troop ship might not happen for quite a while, maybe some days. I say it sailed yesterday. Well, it may not be that the subs won't catch it or the destroyers won't catch it until 5 days from now, but it's still punishable. Though note, the concern isn't that it will cause advocacy, that it will advocate, that it will persuade people to do something bad. The enemy already wants to attack, it just will facilitate it. So it's hard to see an advocacy example. I'll give you one other example that I actually like to give in my classes. So imagine that there is a war, that's sort of a lingering Vietnamesque war, or like the Civil War, and the government says, look, there's a candidate running for office, and he's running on a peace platform. And we have reason to believe that the enemy is therefore emboldened as a result. They were this close to folding. But when they see this candidate is surging in the polls, they figure if only we can hold out till November, we can make a better peace. So as a result, they're continuing to fight. What does that mean? That means more American soldiers get killed. That means more local civilians get killed, just more death all around. And it's all because of this guy who's running on this peace platform. So we have a compelling interest to pass a law that prohibits him essentially from expressing pro-peace sentiments or saying that he would end the war if he is elected. There's a compelling interest in saving lives. This is narrowly tailored to it. I think the answer is no, you can't restrict that because it's a fundamental feature of democracy that people have to be able to say these things even if the consequence is something potentially quite deadly. Now, so I never say never, right? But at least in all the examples that I've seen, all of the plausible, all of the realistic, certainly real examples that I've seen, court generally says no when it comes to the concern being advocacy.
Professor Tubbs.
So I was wondering if you could pull back the slide on fighting words again, please.
Fighting words, you got it.
And I wanted to ask you a question about violence and pornography.
Okay.
Whether you think there's any merit to the concept of group libel in view of what you said about fighting words.
I'm sorry. Violence in pornography or?
Yes, so this is what I have in mind. You say speech that angers listeners,
yes.
Personally abusive epithets.
Directed to the person of the hearer.
Yeah. So I have in mind the argument that certain forms of pornography that depict violence against women
yes.
create the impression that women like being raped, beaten, and so forth, amount to a form of group libel, that it's just demonstrably false that women like
right.
being abused. I want to ask, a personally abusive epithet, that this might be grounds
yeah.
for saying that the speech is not constitutionally protected, yet you're perpetrating something which is false, it really is a lie in the way that most forms of libel involve lying that damage a person's reputation. Which is more cogent in your judgment? That personally abusive epithets?
So first of all, just to be clear, fighting words, the doctrine is limited to things that lead to a violent reaction by the listener who's really angered by it. That's not the objection generally in group libel or in the examples that you give. You might say, well, all right, but group libel is still justifiable for various other reasons. Fighting words is just not a great analogy to it. Because fighting words, the concern is that somebody gets so angry that they punch the person. Really, the concern is that people will become persuaded, the listeners will become persuaded that they ought to do something that they ought not do, which is engage in sexual violence. The rationale of group libel laws, which in fact the court did uphold in a case called Beauharnais v. Illinois in 1952, although for a variety of reasons which I'll be glad to get into, that case has been overruled in a lot of different ways already by now. But the rationale of group libel laws is actually a little different. The concern is that if people are persuaded of false statements about a group, they will end up not so much committing crimes against the group, but treating them badly in a variety of ways. Just like ordinary libel, the typical worry is if you libel me, not that somebody will physically attack you, it's possible, but it's that they'll stop doing business with you, right? So the group libel rationale, again, it's been rejected in various ways, but part of the rationale is you don't want to put the government in a position of trying to determine what is false and what is true, and what is factual statements and what is opinion, when it comes to statements about kind of big picture social policy.
But libel law always requires some determination about whether something is true or something is false.
I understand. So interestingly, there was a petition for rehearing filed in Beauharnais v. Illinois by the ACLU, co-signed by Thurgood Marshall, who argued, in fact, you do not want to have group libel laws because group libel laws will be and have been deployed against people who are criticizing the white establishment, for example, on the theory that's group libel of whites. So, as it happens, the track record of group libel laws is actually pretty weak, in part because it's very easy for the government to say, well, yes, these statements are false, even though they're actually opinion or they're true. No, you're absolutely right. And actually, I wrote an article on this very subject a couple of years ago, that in ordinary libel law, we do decide what's true and false about Volokh. If you accuse me of something, then there could be a jury deciding. But we don't usually decide what's true and false about crime rates, what's true and false about whether Jews have undue influence in Hollywood, let's say, or a variety of other common kinds of claims that are made. And it's an interesting question why not. The Supreme Court has made clear in a case called Alvarez that we don't. And I think part of it is we just distrust government decision-making about kind of social science questions and history questions and various other such things more than we distrust its decision-making about what happened to a particular person. But one thing that's interesting is the very example that you give. So it rests on this assertion that people who watch violent porn come away from it with this belief. And the answer is some people might not. But I think it's pretty clear that most people recognize that violent porn is fantasy, just like a lot of movies are fantasy. Now, it may be that certain kinds of fiction lead people to have bad beliefs. But at this point, you're outside of the category of true group libel, which is just pure factual assertions. And what you're saying is certain kinds of fictional depictions that most people recognize are purely fictional might still be criminally punishable on the grounds that some people will come away from it getting bad factual judgments. And that, it seems to me, is an illustration of the slipperiness of the line between fact and opinion.
Just because the law used to distinguish between the most vulnerable or impressionable members of society, including children, people below average intelligence, and so forth, right? So that's the complexity which I think
right? The law used to distinguish that. It was, in fact, the premise for a lot of kind of old, broad understandings of obscenity law. And even when it comes to obscenity, the court has tried to retreat from that on the theory that, look, if you ban certain kinds of material because some unusually impressionable or people who get the wrong impression from it do bad things from, then you're going to be banning a lot of material. But in any case, I'm sorry, this is a very long, I'm sorry, what you're asking is a question that has a very long history and a great deal of analysis. There certainly are lots of people who have advocated for group libel, for revival of group libel law and for violent pornography laws. But I do think that this very example helps illustrate the difficulty in drawing the distinction between factual assertions and opinions and fiction. Because what we've got is something that most people clearly perceive as fiction. I think many people in this room who watch pornography of various kinds, and probably virtually, pardon?
Not in this room.
And probably virtually all of the people who have recognized that this is not a documentary. Nonetheless, that's now being treated as tantamount to libel, tantamount to a false factual assertion. That is the kind of slippage that critics of the group libel doctrine have warned about.
Eugene, why do you suppose, I just wonder, I don't know, why has the court actually never said the words with respect to Beauharnais, we reverse? It's not like Korematsu where they just haven't been presented with the opportunity to do that. They could have done it several times.
Yeah, the group libel statute in Illinois was actually a pretty unusual statute at the time. There are no such statutes that I know of that are currently being enforced. So I just don't think it's had occasion to confront it. If you're, it has rejected many of the premises there. So one premise of Beauharnais was that truth is not a perfect defense. That was rejected in Garrison v. Louisiana, and there are many other such examples. I guess our time is up.
And with that, I ask you to please join me in thanking Professor Volokh. Thank you, Eugene.
Thank you.